Good morning, everyone. We'll call this meeting of the House Ag and Natural Resources Committee to order. Clerk, would you please call the roll?
Representatives Fritz, Grills, Hardaway, Harris, Holsey, Hurt, Jones, Marsh, Martin, Reedy, Ritchie, Shaw, Travis, Vital, Wright, Vice Chairman Darby, Chairman Todd. Mr. Chair, you have a quorum.
Thank you, Mr. Clerk. And the first thing that I'd like to do is I appreciate everybody being here today. If you cannot find a seat, we're going to need to ask you to go out in the hall. There's a monitor out there where you'll be able to watch. But fire marshal concerns and the capacity of this room, we need y'all to either find a seat or watch out in the hall, please. Thank you. At this time, we'll get started with our Pledge of Allegiance and our morning prayer. Representative Grills, would you lead us, please? Everybody stand, please. Thank you. Any personal orders today? Representative Reedy, you're recognized.
Thank you, Mr. Chairman, and it's an exciting day for Stewart County High School today. Today with me, I've got a job shadower, and her name is Kaylee Bennett. And actually, due to the capacity of this room, I have connected her with Carol McDonald. She's in the back with Miss Carol, and that way she can ask some questions about what's going on in this room. But not only that, we've got Maddie Sizemore. She's a job shadower from Stewart County as well, and she is connected with J.C. Bowman with Professional Educators of Tennessee. That's a good connection right there, talking about education in the state of Tennessee. Let's make them feel welcome.
Any other personal orders? Representative Grills.
Thank you, Mr. Chairman, and I would like to also welcome Mr. Benjamin Gillette. I don't know if he's in here. He may have had to walk out due to the crowd size. But anyhow, he is from the Eagle Forum. He is he has 3 older brothers and a younger sister. He's 12 years old. He's here just to job shadow and kind of see what we do on a daily basis. So I hope he has a fun day and learns a lot. And also, I would also want to brag on my oldest daughter. I didn't get to go last night because I was up here, but they had their volleyball awards banquet, and she plays on the 6th, 7th, and 8th grade volleyball team from the CCA. Well, I got a picture, and she got the MVP of the volleyball team, and I was super surprised, proud, and, I hated that I wasn't able to be there. And the best thing about it is she doesn't even know how valuable that is. So, anyhow, I'm proud of that.
Representative Travis.
Thank you, Mr. Chairman. And today we have with us in the crowd a lady that has perfect attendance in school, but she's here with us today. But if she takes notes, her teacher's going to let her continue that perfect attendance. So Hayes Ledbetter, if you would stand up and let people see who you are. There you go. Oh.
Any other personal orders? All right, Representative Vital.
Thank you, Mr. Chairman. I just want to recognize that yesterday was National Agricultural Day and pay homage to all the farmers, ranchers, landowners, those that are committed to conservation and growing our food, and we appreciate them across the state and across this country. Thank you.
Thank you, sir. Absolutely. Absolutely. Just a historical item for the day. In 1933, the Roosevelt administration created the Civilian Conservation Corps. The Corps was designed to put young men with bleak employment prospects to work on public improvement projects. By July of 1933, nearly 300,000 men had worked in 1,300 camps. Some of the jobs were ordinary road construction and others were unusual. The Masonry Bridge near Crossville, Tennessee is one of those projects the men undertook, which has the appearance of a Roman aqueduct. In many areas of the country, it provided public improvements that remain to this day an important part of the nation's infrastructure. The legacy of the Civilian Conservation Corps is a collection of well-constructed bridges, watercourses, buildings, roads, conservation and projects built to last, including the bridge and dam at Cumberland Mountain State Park, where I used to work. It's always a beautiful sight to see, to go visit that park and see that wonderful construction. We'll begin with our order of business today. The first items we have, a couple of items. Item number 2 on your calendar, House Bill 980 has been taken off notice. Without objection, it's off notice. Item number 3, House Bill 523, has been requested to be rolled 1 week. Without objection, we'll roll that 1 week. That brings us to item number 1 on our calendar, House Bill 447 by Chairman Sapicki. Chairman Sapicki, you are recognized. You have a motion and a second.
Thank you, Mr. Chairman. I'll be requesting a roll call on every action taken by this committee on this bill. Mr. Chairman and members of the committee, unfortunately, last week we were cut a little short on time on another bill that you were debating and arguing. I would request that we have people that were testifying last week, let's go back out of session and allow the committee to continue with the questions they were going to ask, Mr. Chairman.
Thank you, sir, for that. I certainly had planned to do that. If there are no objections to doing that, we will go out of session at this point. We're out of session. If Mr. Kennedy, Murphy, McEwen, Howard, and Hardin will approach and find one of the seats there, we will have members of the committee ask you questions, since you've already spoken last week, and get anything off their minds that they wanted to ask from last week's testimony. When you're asked a question, if you would, please state your name and then give the answer, please. So I will, at this point, entertain questions from the committee for these members. Representative Ritchie.
Thank you, Chairman, and thank you for coming back in again. I think I've spoke with almost each one of you after the last committee meeting last week. One of the questions that I had, and I took notes when each one of you spoke, but I'll position it to Commissioner Gabe. You referenced, we can go back and watch the video, but almost verbatim, we're asking for help against Trinity. And for me, that makes this more of a property rights issue or more of a battle locally. Can you elaborate on what you meant by we need help against Trinity?
And feel free, you're recognized, but feel free for just to go back and forth to save time without coming through me. As long as y'all keep it civil and don't talk over each other, we'll do that.
Thank you, Mr. Chairman. Thank you, Representative Ritchie. Definitely appreciate the time that you've spent with us and kind of talking through this. This is not a conversation about them specifically in any way. This is about protecting the Duck River and the water that our community drinks, that our agricultural community uses in their crops, and their agricultural producers that also use that water for their animals.
Thank you, sir, for elaborating on that. And then anybody else that's sitting up, as I went through and took notes, Sam had mentioned this is the Monsanto's mess that we're taking a look at. That right there goes back to property rights. When we looked at next gentleman got up there and spoke, we had just voted on a bill that was HB 1056 that moved on out of this committee, which was what is the application, not what is the intent. And that just resonated when the conversation was going on as far as for the fears of what could or maybe or might possible happen with this particular one landowner that has that property. If somebody can elaborate on why that is, I'd appreciate that.
Representative Ritchie, thank you for the question. I want to make sure I understand exactly what you're asking.
Would you please state your name,
Oh,
sir?
I'm sorry.
That's
Daniel
okay.
Daniel Murphy. I'm the Murray County attorney. we've been up here so much, it's gotten to where everybody seems they know everyone, so I apologize on that. So I want to make sure I understand your question exactly when you say why that is. I want to make sure I answer your question as you're asking it, please.
And I'll clarify. So whenever you spoke last week, you mentioned that there's zoning concerns that are taking place with the particular property. But the bill that we passed just before we took this bill up discussed what is the application at that point, not as what is that application's potential or intent further down the road. And it just resonated in my head when you were talking about the zoning that day, that we don't even have any idea or clue what would end up being a particular business or company's intent 6 months, 1 year down the road when all the applications and permits are not even in there. So I just wanted a little bit more clarification on the zoning concern when there's not any, maybe I'm unaware, but has there been a zoning application submitted to be able to change that?
No, sir. There's been no application made with Maury County for a business license, for a site plan, for any zoning application. This property is still zoned M2, which brings a whole host of abilities that this property owner can use for their property. And as it relates to the intent and application, this law just is a protection of water rights, recreational rights, as afforded in the scenic river. It has no impact on the current zoning that this particular property owner has, and that's not what we'd want to do. Any permits that are issued on this property by TDEC is issued by TDEC subject to their rules and regulations. It has nothing to do with our zoning. That's still TDEC's rules and regulations.
All right, thank you. And then I did want to share with Dan, whenever y'all were up here speaking last week, you, I believe it was Sam, right? I'm Dan. So it is Dan. So Dan was the first individual that got up out of the group and actually did speak to the heart of this bill, in my opinion, and about protecting the waterways and why is it important. Can you elaborate a little bit more on that? Because out of the 5 individuals that got up and spoke, a lot of the conversation was about property rights or trying to block a potential business owner from trying to move forward with something. And you were the first one that actually spoke up on what's the actual heart of this bill and protecting the waterways. Can you elaborate a little bit more on that? And that's my final question, Chairman.
Thank you, Mr. Ritchie. Can everybody hear me okay? Thank you, Mr. Ritchie. I'm Dan McEwen. We are here because the Duck River is our greatest natural resource. It's our only water source for our community. It's the only source of water that we use for our agriculture, and that's the issue. And we do not believe that this eliminates anyone's rights to do anything. Those are already in place, and the river is important for many generations to come.
Next on the list, we have Representative Fritz. And again, you feel free to go back and forth.
Thank you, Mr. Chairman. I do have several questions, so I'll if with your all's permission, I'll just direct them generally. And I do want to say I appreciate all of you all have shown up for this. This is the way, it's great to see public engagement. So my first question is simply this. Is there a current environmental impact statement on this property? And does law require an update of such to conduct the operations that are planned or proposed by the current property owner?
I'll take that question. I don't know that there is TDEC controls what happens on this property. It is under some of their jurisdiction because of past activity that has gone on that property. So what they may require, I would leave for TDEC to answer that question as far as going in the future and what environmental impacts that they would request.
Okay, thank you. I'll go ahead and ask. There may be several of those questions that may be the answer, and we can go back perhaps with the chairman's permission to those. Does the current zoning resolution that's in place allow the owner to perform the operations he's indicated or proposed to conduct on the property?
Well, he's not proposed anything with the county. There's been no county application. The only thing that I know about has been, there's been two applications for a landfill. Those issues, I would argue, that are not because of our zoning ordinance. There also have been 4 applications submitted to TDEC for some processing facilities. There's not a lot of information that we know about what those applications were. Those applications were originally granted, but because they actually said that the Jackson Law didn't apply when this was actually within a mile of the city of Columbia, TDEC has gone back and revoked those permits. And so I will say this in general terms, some of those processing items that they've looked at potentially could fall under this area. I mean, it's subject to site plans, permitting, zoning, and those sort of things. But yes, some of the things that they've talked about, well, I say they talked about, that we've seen discussed are potential uses on this property, but without more information, it's difficult for me to say yes or no for that.
Thank you. And I do want to just clarify the reason for these questions. I think this is one of the most significant things that we'll look at, that I'll look at this year. So I've had lots of late nights looking at this, and I appreciate you all. That's not a complaint. I just take this very seriously.
Representative Fritz, would it be appropriate to get the complete answers on your questions to call someone from TDEC up at this point to be able to clarify some things that these folks might not know about potentially? And I'll leave this up to Ms. Beatty or Mr. Tipton, but possibly Lisa Huey. That be the most appropriate for this line of questioning? Mr. Hooper? Okay. Jeremy Hooper with TDEC will come up, and you're free to either sit in one of the chairs or stand at the podium, either one. And if a question needs to be restated, feel free to do that, and y'all just go back and forth and
for sake of time, I'll try to be as fast as I can.
Sure.
Thank you, Mr. Chairman. And I'll repeat that last question. Does current zoning resolution allow the owner to perform the operations he's either planned to promote or proposed on this property?
So Jeremy Hooper with TDEC's Division of Solid Waste Management, and thank you for the question. The only applications we have received are solid waste processing ones. Those are currently subject to Jackson Law. So at this point, we can't review them until that process is finalized.
So that leads to the next question for the panel, if you will. Is there a process in place by current law and current regulation that would, following that Jackson Law determination, allow a decision to be performed? Yes or no?
So if the Jackson Law plays out and those applications are voted down, we cannot review them and approve them.
Okay, all right. So it would be, the applications would be dead?
Those applications, the processor ones I'm speaking about, yes.
Okay, all right, thank you. Just a couple other questions. Is there an appeal process to the zoning that's currently in place for the owner of the property to pursue if the zoning currently did not allow the operations in place? And this is prior to the Jackson Law.
Prior to so you're not talking about the Jackson Law process?
No, sir.
I'm not familiar with those.
I can answer that question. Zoning is appealable to 2 issues depending on what they request. One could go to the Board of Zoning Appeals determining what they may be asking an appeal for, or if they say, oh, that zoning is arbitrary and capricious, they can always go to court and seek that remedy there. So I hate to sound like a legal answer, it depends. It just depends on what the facts are and what they're looking at.
Yes, sir. And Chairman, thank you so much for your patience. 2 more quick questions and then one quick statement. Is there a possibility that the current site conditions could be better monitored if there were active operations on the site? and this may be a TDEC question, would there be an increase in NPDES sampling? Would there be an increase in air sampling operations? And would there be an increased sampling of groundwater? Would the plume that is sampled be increased in size?
I can only, excuse me, I can only speak to the solid waste requirements. If you want someone to talk about NPDES permits, we probably need to bring up someone from our water resources.
Okay. So what would the answer to the air then for the
Well,
solid waste?
sorry, I'm also not in the air pollution group. I apologize. I'm not familiar with the air requirements.
Okay.
Do you want someone from Water Resources?
We can go back to that if you'd like to, Mr. Chairman. I think it's a pertinent question. And the last quick question I'll ask, and thank you again for y'all's time. As a matter of fact, I think we've answered that one. I'll close with this. I just, and I talked to the good folks from the county commission that dropped by my office. It is great to see the engagement. I want you all to hear my heart on this, that there's I think we have in a constitutional slippery slope in legislating where there's current law in place. And so you see the directions of where some of my questions are going. I want you to hear that from me just in full transparency. Thank you, Mr. Chairman.
Chairman Grills?
Okay, thank you, Mr. Chairman. And anyone can answer this question. First off, I want to give a shout out to how y'all's, everyone from Murray County, they've reached out to our office and they've come by and seen us, and everybody has been extremely cordial. And that's not the way it always is around here, and I really appreciate that and the hospitality and the just the decency that y'all have displayed over the past couple of weeks. There seems to be a fear or a concern if we do not classify this Duck River as a Class 2. What is that concern? What is that fear? And where is that coming from? Whomever wants to answer it.
Sam Kennedy, Representative Grills. I'll just say, in general, Murray County's changing fast. We've had tremendous growth, which is good, but we recognize that if we don't intentionally sort of take some measures to protect our most important natural resource, which is the river, it will, it won't be the same that it is. It won't be the same quality that it is. So, regardless of the current situation, we're looking several generations in the future, how we're going to protect our water, and we think this is a practical measure to do it.
So, what is the fear, though, that if this quote-unquote landfill were to go forward, that this would somehow contaminate or devalue the river or the properties that are along the river? And I don't want to put words in your mouth, but that's kind of the impression I'm getting.
Yes, I think that'd probably best be answered by Mr. Hardison here from CPWS.
Thank you, Representative Grills. My name again is Jonathan Harden, President and CEO at Columbia Power and Water Systems. As a municipal utility provider, we're in the business of trying to avoid risk. And we know this stretch of the Duck River, and we're mindful that any change in conditions near this stretch of the Duck River could make it more difficult for raw water supply related to providing essential services to the Duck River watershed. That is certainly an issue when you have a $400 million program that is based off of this area of the river for water supply.
But how is this, if this does not get classified, how is that going to affect that?
I will just say that I'm privy to the fact that the EPA just last week introduced the fact that it is widely known that PFAS will leak from municipal landfills. PFAS is PFAS. It's a compound that comes from Teflon and nonstick coatings, prevalent in municipal landfill settings. It's an emerging contaminant of concern. There's discussion on regulating it to the parts per trillion. These are the types of risks that, when they're unknown, you have to invest time and money into understanding them. That certainly can have rate implications to folks who are depending on you for essential services, and we're not in the business of accepting any avoidable risk when we have $400 million at stake for essential services to the Duck River watershed.
Now, you say you are the director for, give me your title one more time, please.
I'm the acting president and CEO for Columbia Power and Water Systems, the largest utility provider in Murray County.
Are y'all having any issues? Because I have been told that there has been some pollution coming from the wastewater plant there in Columbia. Is that correct?
The return flows from the wastewater plant are at least as clean as the river itself. The condition of the river has not been an impediment to TDEC's willingness to issue a permit for raw water withdrawals, and we anticipate that very soon.
So y'all are not, there's not any contamination coming from the Columbia discharge? What?
That is not creating any issues for that stretch for raw water supply.
Now, maybe someone else can answer this, or maybe the attorney. Are there any active landfills or landfill permits that are along the Duck River that are within this 2-mile stretch that this would possibly change currently?
The only two active permits that I know of is one is for Chickasaw Trace, which is actually was a county landfill. And I say it's active in name only. That landfill has actually been capped and waiting on final grades to get the final closure from TDEC. So it's not accepted waste in last couple of years, and like I said, it's capped and waiting that final closure. The other permit that is issued is the opposing landowner that has been here has a 6-acre Class 2 landfill that was for the property located or for waste created on that site back when Monsanto was being dismantled.
So those are the only two permits?
That are within the scenic area designation. There's one other landfill that's just outside of that area, is a Class 1 landfill that I just actually learned about that the county has a permit for. It's a small landfill that was actually permitted in the early 90s when the large landfill that the county had closed. Nothing has ever gone into that landfill. It actually is not, it's not suitable to receive waste. It was a permit that's held, and I just found out that, yeah, we just held this permit because the past solid waste director thought we may need somewhere to put something until we got things worked out with the Cedar Ridge landfill in Marshall County, and that has worked out. So I anticipate that permit being discussed and potentially going away real soon.
So that permit that you're talking about there, that's been active since 2013 when Murray County designated the Duck River as a scenic river?
Well, make sure that permit was active actually in 1991.
So y'all have maintained its activity every year since then?
All that has been done is somebody paid a fee. It actually has not been monitored because it's not even received waste. So it's not an active landfill as in ever receiving anything. Never had a liner or anything like that. It was somebody pulled a permit when the other one was being closed, and like I said, okay. I actually just realized that when I was reading TDEC's website and said, what is this? And I contacted them and said, we thought it had gone away, but it's just something that's just been there that they send the fee in with the other items that we have.
Okay. So,
and then to answer your question, the 2013, we didn't designate it as a scenic river. We just used the power that the state has provided to the county through zoning to say you cannot have landfills within 2 miles.
okay. But y'all at that point did not relinquish your landfill permit at that point?
We did not,
Okay.
because I don't think anybody realized it was still there and part of the process.
So somebody was paying a fee every year for something they didn't realize they had?
Exactly.
Okay.
And I think it's going to be addressed here shortly.
I understand that.
Mr. Hooper, this is your area. Do you mind adding to or taking away from anything that was said there as far as what the facts are?
Sure. So according to our records, there are 4 active landfill permits within this stretch that would be 2 miles. The county Class 3 landfill over by Chickasaw that he mentioned that is in the process of closing. The Class 1 permit that he just mentioned that they are paying for but has never been constructed or operated. The one at the Monsanto property that is in question here. And then there's another Class 2 from Graph Tech Industries that also may be on the verge of closing, but is still an active permit.
Go ahead, yeah.
The Graph Tech landfill is actually outside of this area. It's almost in the city limits of Columbia. It's in town.
Okay, so it's not within the 2 miles.
Correct.
Later on. Is that correct, Mr. Hooper?
Our analysis suggests that it is within the 2 mile.
Okay. Thank you. Chairman Todd, you can.
No further question for you? Okay. Next on the list is Representative Holsey.
Thank you, Mr. Chairman. And I can't remember from one week to the next. I mean, sometimes I can't remember this morning, so I might have to go back and recap. In 2013, your county commission passed a zoning ordinance that in this particular case, with this particular property, they would not be permitted to operate a landfill. Is that correct?
Well, it didn't apply just to this particular property. It applied to the entire Murray County.
Okay.
And so any property within 2 miles of the Duck River would not be able to operate or to have a landfill is what that zoning resolution did.
Okay. That passed in 2013.
Yes, sir. I believe December of 2013.
Okay. At some point back there, there was a discussion about this landowner being grandfathered in from that zoning issue. I tried to run down the process of being grandfathered, and it's my understanding, and as a lawyer, counselor, tell me if this is correct or not, that grandfathering would be from a site that is existing and has not stopped. It is a continuous business that's going on that could be grandfathered, but it's my understanding that this particular, and again, here's another question. This permitting process on this particular piece of property we're dealing with only applies to 6 acres. Is that correct? Let's answer that first.
TDEC may want to answer that exactly.
Well, to be clear, we haven't received an application for a landfill.
Okay. So the old Monsanto place is 6 acres.
Yes, that's correct.
Okay, and there is no existing permit for that at this time?
There is, and it's 6 acres, but we just have not received an application pertaining to it to do anything else with it.
Okay. If somebody had this set up where you've got a permit for 6 acres, a couple of questions. Does that permit allow you to expand to adjoining property? And the second question is, can you be grandfathered in if there hasn't been any activity in this 6 acres?
So to the first question, a permitted landfill can apply for an expansion. Should they meet all the requirements, regulations, state law, then we are required to issue that expansion. Whether or not this legislation would affect them, would grandfather them in, I'm not sure. That would be a question for an attorney.
Counselor, can somebody be grandfathered in? And if so, to me, it was based on use, not on plans. Is that a correct assessment?
As it relates to the county, you would have to have continued operations on the property to be grandfathered in. If there's a 30-month cessation where there's nothing that's happened for 30 months, then there is an argument that I say an argument. I'm a lawyer, I argue. That it would be my opinion that they're no longer grandfathered. If they don't operate, which this business closed, Monsanto closed in 1986. From my discussions with the prior owner, there's been nothing put in this landfill when he purchased the property in 2009 until he sold it in 2022. Now, according to zoning applications that were made back in 2016 regarding when they split some of this 5,300 acres off, they rezoned another 1,300 or so acres from M2 to A2. And when they did that, they gave a history of the property which they said it closed in 1986, and that they secured the property, and all they've done is monitored and maintained it. There has been no operations. That's what was put in zoning applications and public records with the county.
Okay, let's say that he legally could be grandfathered. That's just hypothetical. If we made this river a Class 2, would he also be grandfathered under that Class 2 designation as the river? Or maybe that's a TDEC question.
Well, that's a TDEC question. As it relates to their, we've got into a lot of property rights issues, and particularly around landfills. There is a current landfill permit on there that has conditions of that permit. The conditions that are in that permit are actually in TDEC regulations that had been there for many years. Number 7 of their permit, and all permits, I shouldn't say just their permit, all TDEC permits on landfills and any other permit, addresses property rights. And it specifically says this permit does not convey any property rights of any sort or any exclusive privilege. That's the permit that they took over for this 6-acre landfill. The county permit has the same language in it.
Okay, I don't have any problem with designating a Class 2 river to keep water clean for your county. I have no problem with that. But speaking of that, if 8 miles of the river above that area is pristine and clean, why would that not keep the 8 miles that you want pristine and clean?
You're talking about the section that we're not
You're proposing,
naming?
yeah.
Yep. Well, there's 2 reasons for that. One is that area of the river runs through basically downtown Columbia. That's a developed area. You have roads beside it, you have houses, you have businesses, which are not contemplated in a Scenic River Act. But probably the most important reason as to why that would not be named a scenic river is there's actually a dam in this area. It creates an 8-acre impoundment of water, which is where the city of Columbia has its water intake. So you cannot have impoundments on scenic rivers. So I don't even think that would be thought about until we for sure have a downriver intake that would be able to meet the long-term needs of the city of Columbia before we would say we got to remove a dam and do away with this impoundment. So that's the primary reason. Is it just doesn't meet the definition because of the impoundment.
Okay. I've got some more later, but right now, thank you.
Right, and I might go to Mr. Hooper on any of the comments about the language of the permit. That's your expertise.
Yeah, I mean, what he said is in the permit. And so I guess, it doesn't supersede any other requirements or laws or anything like that. It's just specific, the approval is specific to our regulations and what we have authority to respond to.
Okay, thank you. Next on the list, we have Mr. Ritchie.
Thank you, Chairman. And for Mr. Hooper, question would be, or a question I have is, with the existing 6-acre permit that is there, what are the steps for that to be continued as far as being actively run or even expanding, and what would be the time frames that we typically end up seeing coming through TDEC with applications and things of that nature?
Sure. So it is currently being actively run, and they can do that per the existing permit. If they want to expand, so just generally speaking, how that works is for our process is any Jackson law, if Jackson law is applicable. So to be clear, we haven't received a proposal. So I'm not saying this is relative to any sort of application we've received. But when we get an application, we think, okay, is Jackson law addressed? Is it applicable? And is the local solid waste Part 8 board approval applicable? And has that been addressed? So just assuming all that is taken care of, and there's nothing stopping it, then we get a Part 1 application, which is essentially a who, what, where. Like, I want to apply for an expansion, and this is who we are. It's like essentially a notice to us that they want to apply for that expansion. We then have 30 days to make sure that it is complete, okay? As soon as that is the case, we have to publicly notice that. So we work with the applicant to do something called a preliminary notice, which is published in the local newspaper, on our website. It's sent through a mailing list of folks who are interested in this type of stuff. It's sent to the local representatives and ask them to post it and distribute it as they see fit. And it's also sent to the local library. So it's just notifying the community that we've received this application. Then we await the Part 2 application, which is the meat of a landfill application. There's two parts. We refer to one as Part A, which is a hydrogeologic study, and then Part B, which is an engineering component. We have 270 days overall to process these, that Part 2 application. Assuming everything goes well or smoothly. So that clock can stop if there are deficiencies that we have to work out with the applicant. So those clocks often do stop. So it's very rare that they run consecutively. But at the end of that running clock, 270 days, we make a tentative decision on whether to issue the permit. And say we make a tentative decision to issue it. We then have to do another public notice. And this is to to tell the community of that tentative decision, but also to start a 45-day public comment period. That public comment period starts once the newspaper notice is published. During that 45-day public comment period, a public hearing can be called by the applicant, by anybody. Should that be the case, that will be held during that 45-day public comment period. It will be noticed in the newspaper. It's often the case that the original notice that starts the 45-day public comment period includes that we are going to have one, because we always check out, we see if we know of anybody that wants to call it ahead of time. So that 45-day public comment period plays out, any public hearing. We take those public comments, see if anything changes, is legally would change our opinion to tentatively issue it. Assuming it does not, in this case, we then issue the permit.
So it's pretty extensive as far as for all the steps and the checks and balances that are in there. And as of today, you have not received any application for expansion or anything, to clarify.
That's correct.
And based on the timeline you just shared, it's probably a 1 to 2 year process before it could even potentially move forward. Because what I've heard from I've appreciated all the phone calls and the conversations and the county commission coming in, but the way that it's being painted as is the gentleman that owns this property, that business owner, is in the process of full steam ahead trying to expand this, and we're still at minimum, it sounds like 2 years out before it could even potentially start clean or moving forward with that right there. Is that fair to say?
Yeah, it's at least a year in most cases, and multiple years for an application to work through the process is not uncommon.
Okay. And then the last question that I had for you, one of the concerns that was shared multiple times to me is the concern of seepage through the different barrier containment systems. I can understand if we're looking at something that was built or developed 20, 30, 40, 50 years ago, and it's been out there and it's been in use. Based on TDEX regulations, federal regulations, when it comes to these new land sites, or if there was going to be an expansion, do you feel that the regulations that are there are sufficient to be able to contain that should this site get up and running 2-3 years down the road?
The regulations are designed to prevent the risk of contamination.
Is there anything in the regulation that needs to be tightened up to make it more stringent to be able to protect the waterways, or do you think it's sufficient to where it's good?
I would have to go back and speak with folks, our geologists, who are more involved with the nitty-gritty of that. So I can't speak to that here.
All right. Thank you, sir.
Speaker Marsh, you're recognized.
Thank you, Mr. Chairman, and thank you all for coming. Thank the audience for coming today, too, and I appreciate your passion and both sides. As you can tell, it's a tough decision up here. We're all trying to figure out what to do, what's right. A lot of times we're up here, we want to do what's right, what you can't figure out what's right. So I think this is really good that we're hearing this. My main concern about all of this is I understand that I want to keep the Duck River clean, just like everyone else. I want to make sure we're not messing over somebody's property rights at the same time. I just feel like that why get the state involved in this? I mean, it looks like to me that there are enough stopgaps and guards to do it in Murray County and Columbia. And I ask myself, why are we getting involved in this? And I'm like, it's really not our job to get involved in this. But then I look back at some of the other legislation that we deal with up here, and we do get involved in a lot of things that we shouldn't get involved in. So it's a catch-22, and I'm very conflicted about this. I think right now that I see your side more than I see the other side. I think the other side knew that the community didn't want a landfill. You had a resolution. The previous owner tried to get a landfill, and it didn't work out. So it's just, it's conflicted, and I appreciate you all telling us what your side of the story is, and I'm interested to hear the other side again, too. So thank you very much.
Representative Martin.
Thank you, Mr. Chairman, and thank you guys again for coming. It's been exceptional to watch this process play out, especially as a new person on this board. My question is regards to previous owners. I mean, how many previous owners have applied and been denied on this land specifically?
The previous owner applied for an M3 zoning, to change from M2 to M3 back in 2013 to get it's a weird process, but they did apply in 2013 to get a landfill. There was a great outcry of the community, probably even more so, if you believe it or not, more so than this, and they ended up withdrawing their application. Then in 2016, there was an informal discussion with the county commission regarding making that landfill a demolition, or I say using that property for a demolition landfill, and they came to the county commission on 2 different occasions, 2 different months, one with TDEC and a geologist going through the history of the property and requesting a demolition landfill. And while there was no formal application, the county commission said it's a 2-mile barrier, we're not going to entertain that.
Thank you.
Chairman Grills.
Thank you, Mr. Chairman. And to Jeremy, just to, I guess, kind of piggyback off what Representative Ritchie asked, if a landfill were to go in there, TDEC has all the process, the steps, the investigatory authority to make sure and to keep this river from being contaminated. Is that correct?
We have a system, we have a groundwater monitoring system that is designed to detect any contamination associated with it. We do regular inspections of the landfill too to ensure it's in compliance, make sure no solid waste or leachate is leaving the site. So we do have a system in to make sure it's in compliance with our regulations.
Are there any other issues with the adjacent landfills that are along the river now?
In that area?
That's correct.
Not that I'm aware of, but I would have to double check.
Okay. Thank you, Mr. Chairman.
Next, we have Representative Vital.
Thank you, Mr. Chairman. Thank you, visitors and guests, for being here. I must say that, again, many of you came to see me on both sides of this issue, and I appreciate the civility that people had. There's passion. There's no more passion involved with anything other than property rights and gun rights that people deal with. There are individual freedoms. There is nothing worse as a property owner to be served a letter for eminent domain also. I've experienced that. I know what the battle's like to protect your individual rights and your property, and to take on a Goliath. Today, we're dealing with an issue that seems like it's a zoning board. I feel like I'm back on my city zoning board, not the agricultural committee. Today should really be about the importance of the Duck River, the Sequatchie River, the Hiwassee River, the Hatchie River, rivers across this state that are in parallel. Just yesterday, Tennessee was listed as the #3 state in the United States on the decrease of farmland. Farmland is just not about agriculture. It's the absorbing factor that purifies our water. The land is important to us. So I understand the passion of the individuals here to protect something that's very important to them. I understand the property rights of an individual businessman. I'm a business person in Murray County also, even though I live in Hamilton County. But I've had more people in Murray County call me that are my employees on this issue than any other issue because they care about their community. I always ask myself, is it compatible with the neighborhood? Is it appropriate? And I ask you something, if there's a 6-acre landfill approved, then you have those rights. But please take into consider the rights of those around you. The public interest, the public good is just as important in its public and property rights as one individual, as the good of the whole community. So I would just make that statement in behalf of this issue. One question for TDEC. Have any other previous owners of this property applied for permits and been denied or approved?
Not that I'm aware of, but I would have to double check that.
Okay. And it is currently M2 from a zoning perspective?
I can't speak to that. I'd defer to them.
Yes, Dan McEwen. Yes, the property, and not, I want to bring back home what we're trying to do. All properties affected under this bill are either M2 or agricultural. Approximately 115 properties are agricultural and 5 properties are M2. None of those properties would be affected under the current zoning. And so that's why all of the noise that's happened is, to me, missing the point. None of the properties would be affected under current zoning, and we want to focus on what you're talking about, Mr. Vital, the future generations of Murray Countyans and keeping us healthy and keeping our farmland healthy.
Thank you for that explanation, and thank you, Mr. Chairman. I would just say, I drive by a landfill every day when I go home. I live on the Tennessee River. Is it appropriately managed? Absolutely. Is it monitored? Absolutely. But in the last 20 years, what started out as a small landfill keeps expanding, and it has not added to the value of our community. Does it dispose of materials and waste? Absolutely. But it's inappropriate in its location as continued growth. And I wish the foresight had been there, and I wish we had had the ability to speak up 20 years ago, 30 years ago, and find a better location for that, because we do need to find a balance for that. So thank you for hearing me. I would appreciate your continued focus, members, on the river as a resource for Tennessee and not just one individual property owner in this case. Thank you.
Representative Hurt. Out of order. Mr. Representative Hurt.
Thank you, Mr. Chairman. Again, thank you all for being here, and I echo my committee colleagues' words on appreciate the passion and the engagement. I've got 2 questions. First would be to TDEC. Are you aware of any other landfills across the state that are on a major river? And if so, what have been the impacts to that river that y'all have seen?
I can't speak to the entire state. I mean, we monitor our landfills for groundwater impacts and potential off-site impacts. You know, the ones I think I would probably be best deferring to our Division of Water Resources on that.
At this time, we have April Grippo on the list to testify on behalf of Water Resources. If you don't mind, take the spot at the podium if you would. And there's a button that turns a microphone on there. Thank you. Just state your name and who you're with.
Hi, I'm April Grippo. I'm the Deputy Director for the Division of Water Resources. And in the interest of full disclosure, I live in Murray County, so we'll stick to facts only.
Read me. Are you aware of any other large landfills across the state that are located on major rivers? And if so, what has been the impact that TDEC has seen on the water quality in those rivers?
Sure. I am aware of, the state of Tennessee, our division does regular monitoring. Every 5 years, we go in watersheds and do extensive monitoring. And then we produce a list of impaired waters. That's called the 303D list, and it's required by Section 303D of the Clean Water Act. And that list does have some rivers that are impaired, and we attribute that impairment to landfills. I think it's important to clarify that I believe that those are older landfills that had historic compliance issues.
Okay, thank you. That's all I have for you. More committee members might have more. My next question would be kind of directed to the Murray County folks. There's obviously a process in place. There's been a official denial, it sounded like at one time, and then the other time maybe more of a denial without pursuing a permit. So there's a process that's in place here. Can y'all, and it sounds to me like you have solid zoning defenses against landfills there in Murray County. My question is, if that's the case, why are we here before the local or before the normal process has played out? And then if those local zoning ordinances are pretty solid, why is this needed? So just can you clarify that for me?
Thank you, Mr. Hurt. This is Dan McEwen. We have been working to make the Duck River a scenic river on the west side of town for much longer than just now. We tried this 10 years ago. We're thinking much longer term. Mr. Kennedy's 8 generations on a farm. We're thinking 2 or 3 generations down the road. This is not something we just started thinking just because of anything currently. So we would like this to happen. We've wanted this to happen for a long time, and we hope it happens in spite of anything else. I mean, it's not about one issue.
Thank you for that. That's all, Mr. Chairman. Thank you.
And Representative Holsey.
Thank you. Just a couple of questions. To TDEC, if we pass this bill and designate the Duck River as a Class 2, does that allow an existing landfill to go on and exist even after we pass this bill?
I would defer to an attorney on that question. I'm not sure.
What do you think, Counselor?
Well, I would defer that to TDEC's lawyers. I know what my position would be, but that's really for TDEC's attorneys to take that position of whether or not that would be grandfathered in.
We'll ask one of their attorneys, their liaison, Blair Beatty, to approach and identify yourself, and we'll give you a stab at the answer to that.
Now it is. Legislative Director with TDEC and part-time attorney. TDEC's permits do not supersede any other laws that the locals might pass. So if there is a zoning law in the books that says something cannot exist, we can issue the permit, but it can't operate until it can follow those local laws. Does that answer your question, sir?
It does. Well, I was going to ask that question, but this deals specifically if we classify this river as a Class 2 scenic waterway, does that allow an existing landfill to keep operating?
I think that depends on whether or not the Jackson Law applies, and that's when we don't know the answer to that yet because that process has not played out. Am I following that correctly, Jeremy? Jackson Law applies when a landfill has been in existence after 1989. I am not sure whether we know or have made the determination or whether the locals have made the determination as to whether this particular landfill, the Class 3, existed prior to 1989.
The Class 2. So, I mean, we haven't received, an application to evaluate this on a Jackson Law perspective. So,
Everything is speculative at this point, sir. If it did exist prior to 1989, then it would be grandfathered in. I don't want to confuse this.
There was testimony a few minutes ago that it's been in existence since 1986, I believe, I don't remember who said that. I think that's
And that would
documented
be a
somewhere.
legal determination that has not risen to TDEC's level yet, so I don't want to speculate as to what our position would be. I think it's still in the hands of the locals to determine whether Jackson Law applies and then make that vote, whether they want to move forward and vote yes on allowing the landfill to go or no.
Well, that is why I asked the question before. If you have an existing landfill, does it have to be in use to be grandfathered? Or in this case, if it sits dormant, is it still enjoy the grandfathered classification? And if it's grandfathered and we pass this bill and allow a scenic 2, then are they also grandfathered under that?
I do not know the answer to whether or not it has to be dormant or active, or if there's a period of time that has to go by where it was not operating. I'm sorry, sir, I can get back with you on that question.
Okay, well, yeah, that's kind of important because to me, you would lose grandfather status if you're not in use, if grandfathering and zoning is to deal with using, not planning.
So I can't say the Jackson Law, I mean, if the Jackson Law is not applicable, even if the landfill's been operating or not, we can issue that permit. We can review it. But, you know, I don't know about the grandfather status when it comes to, or in the operation status, how that affects the decision regarding the Class 2 scenic language.
Okay, that's a pretty big deal, I would think. If we pass this bill, can someone still go ahead who owns an existing landfill, even if it's not in use, get a permit from you?
Yeah, I'd still defer to attorney on that. I'm not sure.
Okay. Thank you.
Sorry, Chairman.
Representative Travis.
Thank you, Mr. Chairman. I do have a question. I wished all rivers were scenic rivers. I passed one back in the early years, and but my question to TDEC is that when we do a scenic river, do we have to have the agreement with all the property owners that's on that river?
I'm sorry, I don't know the answer to that question. I don't believe so. I don't think that I've ever heard. So,
The Class 3.
oh, on the Class 3. I'm sorry, I'm
Yeah.
not aware.
Ms. Beatty.
In order to designate, Chairman, sorry, I was trying to remember who was asking the question. In order to designate, no, you do not need all the approval from the landowners. In order to set the boundaries, which has never been done, which would fall to the Commissioner of TDEC, we would need for the Duck River approval from all the landowners.
And
That's two different things, and I've probably
yes,
confused
that
you.
is. But how long would you have to set the boundaries? Within what period of time?
Within 2 years of the designation.
Okay, thank you.
Representative Grills.
Don't sit down just yet. Thank you, Mr. Chairman. So Representative Hurt brought up something about the local process. So there is a local process that plays out, and that process has it not even started yet?
From what we understand, and I'll ask Mr. Hooper to confirm this for me, there is a regional solid waste board that would first have to vote on whether or not they approve of the landfill, and I don't think that has occurred yet.
So the only local process that I'm aware of is the Part 8 board, which he's referring to. We are aware that Trinity has submitted an application to the Marshall-Murray County Solid Waste Board for consideration.
Okay, so there is a local process that needs to play out, and when that process plays out, then a decision is made. But I feel like now we are now in we're having all these questions that are asked, and so, well, I don't know, an attorney will have to answer it, or a judge will have to answer it. So we have made the legislature a courtroom now, and that's unfortunate for all of us who have become jurors, and when the process has yet to play out. I feel like we're in a sentencing trial when we haven't even got the verdict yet. And unfortunately, maybe that's a bad analogy, or it's a good analogy, I'm not sure. But the next question I have, would you explain to me or us, what is the scenic river designation? Where did it come from? What was its original intent? What was the goal from day one? And does this qualify for that designation or that original intent?
So I am definitely no expert in scenic river designations, but I think that this act, the Scenic Rivers Act, was passed in 1968. It is separate from our regulatory divisions. It's actually in Title 11, which has more to do with parks and conservation. And I think the goal behind that, back at that time, was not necessarily listing a set of criteria that these rivers had to meet. It was more about celebrating not just the water bodies, but the lands around it, and ensuring that they keep the level of beauty and cleanliness, or whatever you would like to call it, in perpetuity. And I don't know if that answered your question fully, Chairman, but
This does this or does this not meet the definition from which this was
I believe
originally?
Scenic River 2s are for pastoral lands, agricultural lands, and there's nothing that we are aware of that would prohibit this portion of the river from being designated.
Okay, thank you.
Thank you for that. And if you want to be on hold for a few minutes, we have one more witness that I want to make sure we get to today that has requested to speak, and it is Tom White. If he is here, if you would come up to the podium, sir, and state your name, and you'll have 3 minutes, sir.
Chairman, members of the committee, my name is Tom White. I'm an attorney with Toon Etrigan and White here in Nashville. I would respectfully appreciate the time this committee's given. It's taken a tremendous amount of time and effort, and that's not unnoticed by my client. We represent people that have property directly affected by this proposal, and it's been said here repeatedly, this is a vested rights, property rights issue. That's exactly what this bill is about. The key is 13.7.208, which is a non-conforming use statute. That was passed in 1973. The non-conforming use statute, grandfathering is called, basically says this: if you've got a use that is appropriate at the time, and there's a zone change, you still have the right to continue with that use. You folks deal with that all the time. It's called grandfathering. That's exactly what this proposal is trying to gut here in this case. If we look at what's taking place here, you've got, number one, the situation is you've got the upper duck with a enactment on it at the present time. What does this proposal do? It skips eight miles of the river, starts down at the industrial area, goes for 60 miles with 2 miles on either side. What about this client's property? We're talking about property rights. This client owns 1,330 acres in this site. There's been a landfill approved on this site since 1986. I don't need to argue with you today about whether it's active or not. TDEC answered that for you. They're very clear. It's active. It's been active, been initiated and reviewed every year from 86 to the present. Now, with respect to that, let's talk about what takes place under 13.7.208. The rights are, number one, you get to remain in existence. Number two, you get to expand on contiguous property. Number three, you can tear it down and build the same thing back. What's interesting, too, is that TDEC's taking care of the issue today about is it active or not. But the section that's important under 13.7.208G4 says that if somebody wants to say it's not grandfathered in, here's what the state enactment from 1973 says. It says government must show there's an intentional and voluntary abandonment of that use. Quote, the burden of proving an overt act of abandonment is on the government. They can't possibly argue that it's not active and not grandfathered. They can't do it. TDEC's proven that today. So what they're basically doing is saying, we cannot take away the property rights at a local level. So we're going to take them away at the state level. Despite the fact of all the questions here today about there's ample TDEC authority and whatever else, they're saying take them away at the state level. It's a huge takings issue, which someone mentioned. Nobody likes takings case. I've tried as many of those as any lawyer in the state. The inverse condemnation, it's always incredibly expensive. And I will say this, 10 years ago, this legislature enacted the Tennessee Vested Rights Act of 2014. Absolutely critical enactment for builder development property owners. And in that case, when that bill was passed, I've read through that legislative history many times. It's replete with comments. We're protecting property rights. Somebody buys a piece of property and relies on it, what's at the time? I've litigated that matter in our trial court, the Court of Appeals in the middle section. The comments by the judges are replete. We protect people when they rely on something when they bought the property. Sid Bryan was asked that when repeatedly he said, I've spent millions of dollars chasing this. What's the purpose here? And I'll close, Chairman. The purpose is this. They've been very clear. We're stopping this landfill. Their public comments are very clear. Has nothing to do with water quality. Nothing. Has to do with stopping a landfill. I appreciate that. Jason Rapture's here. We'll answer any questions that you've got.
Thank you, sir. And we'll open up for questions, and Representative Hardaway is first on our list. Okay, Representative Shaw.
Thank you, Mr. Chairman. Just one question for you. And by the way, I voice opinion of all of the committee. Thank all of you for being here. We appreciate so much everybody being here. I just want to make sure I understood what you said, that the property owner who owns a landfill has 1,300 acres.
Correct. 1,330 acres, yes, sir.
Can I ask you if there's any other place on his 1,300 acres he could put a landfill?
Not under the current zoning, because the answer is that in 1986, this landfill was authorized and approved. That was before any zoning was in Murray County. Murray County did not enact zoning until after this landfill was started. And so from that point forward, you could not have another landfill because they're prohibited. This one's grandfathered in. So I want to be clear right now, there could be no other place on this 1,330 acres other than what is currently approved. And TDEC has answered that today.
I'm trying to understand that you're saying that because it's grandfathered in, he couldn't voluntarily decide that he just want to move the landfill someplace else because it's grandfathered in. Is that what I'm hearing you saying?
He absolutely cannot move that to any other part of his property because it would not be grandfathered in. 13.7.208 says you can either remain where you are, you can expand on contiguous property. And that's what the gentleman from TDEC commented about. If there is an application, you've got all the state processes in place to see if they can expand from that 4 acres to the additional 2 acres of 6 that are allowed. But at the end of the day, he has absolutely no legal authority to move this operation to any other part of his property. It can't be done. It's not this is grandfathered in right here, no other place.
Could I refer to TDEC for just a moment, Mr. Chairman? What if he decided he didn't want to put the landfill where it is? Would he have a right to reapply anyplace else, just hypothetically?
So apply anywhere else for a landfill to be on that 1,300
On his
acres?
on his 1,300.
They can apply with us, whether or not, the local zoning and stuff would stop it, would play out at the local level. They can apply for it. Doesn't mean we can ultimately approve it.
But he could apply.
Sure.
Thank you.
And I'll comment, you can do a lot of things, but that's like the Easter Bunny. It's just not going to happen. When it's prohibited by the local zoning, you have absolutely no, I'd be telling a client, you're wasting your time. You can't go anywhere else. And I also want to comment, we appreciate the civility of all the people that have been here today. We've had untold comments, meetings with them, as you have. If everything was done this civil in this country, we wouldn't have the problems we've got right now. It's been great civility, which I appreciate. We've mentioned that to the people we've dealt with, Hope. I want to make that publicly clear.
Representative Ritchie.
Thank you, Chairman. And just wanted to echo some of the comments that have been made by some of the colleagues up here. The state of Tennessee is continually growing from the number of residents that we have. A colleague from Hamilton County mentioned about the eyesore landfill that's expanding. It's better to be expanding on a landfill than in your front yard, is my opinion on that right there. What I think we've got right here, and I've mentioned it 2 weeks ago, and I've shared this with everybody else from a concern standpoint, is a property rights issue, and we've got a weaponization of a Class 2 designation of water. And the only reason why I'm even sitting up here right now is because in 2019, the General Assembly body passed a law making my company illegal as well, without any input or feedback from that right there. So because of that standpoint, I want to protect the waterways. But I look forward when we go back into session because I believe there's an amendment for a Class 3, which I think is more suitable because like my colleague sitting next to me mentioned, it's like we're at the sentencing before we've ever actually had the verdict, and we're trying to make a decision on something taking place that the correct procedures and application processes are already in place at this moment. I just want to make a comment. Thank you, Chairman.
Thank you, Representative. And I'm going to mention we've got 15 more minutes in this room, and so I want if we can move it along. If y'all intend to take action on this today, but we're at a hard stop at 10:30. Representative Halsey.
Thank you, Councilor. Inverse condemnation aside, do you think if you are grandfathered under the zoning from 2013, would that also allow you to be grandfathered if we made this a scenic 2 river? Would you be grandfathered with that act as well?
In my opinion, we absolutely would not be grandfathered in. If the state did a Class 2 because the locals don't have the authority to stop it. I think it basically is a takings. We cannot operate under that basis. That's been our advice to the client. He asked us repeatedly before he bought the property, the legal opinions. Jason Rapture's here from Barge, was a TDEC person for 5 years. We've told him the same thing. If there's an enactment at the state level, because basically this Class River 2 is being weaponized, basically we have a takings lawsuit, period. We're not looking for that. That's why we're here. It's a takings lawsuit. It's millions of dollars. We're here to totally avoid that if at all possible. We'd have no problem with the Class 3 designation. It's a Scenic River Act. What is it talking about? Scenic River. We're not weaponizing the Scenic River Act. We're basically trying to protect the scenery from the river. We're doing that. There's not been one person to come here and say this operation would be a pollution problem in the Duck River. We've heard the exact opposite. They've got all the monitoring, they're doing this, they're doing that, and the site's active. I respectfully submit to you, I don't think any lawyer that knows land use law is going to tell you that if this is passed, that this site would be grandfathered in under the local zoning. Nobody can argue that knows anything about zoning law, in my respectful opinion.
Okay, thank you. Counselor for the city, do you agree with everything up to that point?
Well, I think we've really gotten I think we've gotten a little bit of far field. We're arguing grandfathering rights to a landfill through a zoning argument. Zoning is M2, they will continue to be zoned M2. The property rights to this landfill is in the permit from TDEC. And TDEC specifically said, you don't have property rights to this permit or any privileges thereto. We've gotten a far field to mushing this together. They're zoned M2. If they want to say they're grandfathered M2, they're grandfathered M2. I have no argument with that. TDEC, in its wisdom, and I usually don't say that about TDEC many times, they frustrate me, but in their wisdom for many years has put in their regulations, their permits do not create property rights. So it's not a taking. They do not have a property right to this permit.
All right, thank you.
And Representative Hardaway.
Thank you, Chairman. I'll be brief. The city attorney, city or county?
County.
County attorney. Is there, from what you just described, there's a difference in the argument for the permit versus the actual land when we're discussing property rights?
Yes, sir.
So what we're about to vote on will not impact property rights as far as the land itself, but possibly the permit, or it will not because of the language in the permit. Will we override that permit language?
Well, that would be a question for TDEC to answer, but your vote today is will not have one impact on their M2 zoning. They still got a TVA substation there. They still have a railroad spur to be able to use that property for any number of manufacturing opportunities.
Yeah. I'll comment. Dan's a friend and a good lawyer, but basically what he is not stating correctly here is that what's in the TDEC permit is one thing. That's totally trumped by the grandfathering provision. In other words, all the rules and regulations of TDEC are subordinate to 13.7.208. And that's the 1973 enactment like this, exactly like the Tennessee Vested Rights Act of 2014, that recognize what's on the books at the time you buy and operate stays in existence. That's our whole argument. We have no issue about complying with every TDEC requirement. We made that very clear. I want to say that publicly. Ask for any nuances, no variances, no nothing. We want to go through the process. Everybody's asked here. The TDEC has said we do it correctly. We're not concerned about this landfill being an issue on the Duck River. That's it. It's a scenic river's weaponization to basically avoid the landfill. The public comments by the people on the other side are very clear. What can we do to stop Trinity? I mean, it's very clear. I'm not making that up. It's public. So that's the whole purpose. Don't weaponize the Scenic Rivers Act. Go to Scenic Act 3 if you want to, which basically takes care of the scenery and the scenic river. It doesn't basically put a business out of business, which, as somebody said, could be a significant takings issue. We're not here to argue litigation. We do enough of that over at the courthouse down the street. We're here to urge this group to disapprove this bill for all the reasons that I've mentioned. And again, we're here. We'll answer any questions. and appreciate the civility by this committee and everybody else, but it's really a basic property rights issue. It can't be any clearer, in my opinion. I'd urge the group to disapprove it or do the Class 3, which is for Scenic River, and not weaponizing it to take somebody's landfill rights away.
So will your argument, if it comes to that, and it comes to a lawsuit, be statutory or constitutionally based?
Yes, I think if this bill passes, it's a takings of the property for all practical purposes, period. That's what is being weaponized to do. In my opinion, that's a lawsuit where the state's the defendant. We're absolutely making it clear that's not what we're up here to do. We're here basically to get this resolved on a basis where the state should not take away property rights that local government has said, we don't have any other tools to keep this landfill from staying active and in business. Let's go to the state, let the state take their property rights away. It's absolutely the wrong thing and something this committee in particular has always stood against. They were very instrumental in the Vested Rights Act of 2014. I testified in front of that committee. The comments were replete. We're here for property rights, always.
All right, thank you. And Mr. Chairman, I'm certainly not a perfect legislator. A lot of this is, I think there are so many contingencies, ifs, ands, and buts that still haven't played out. But I'll tell you, if I have to err, I'm going to err on the side of the people. So I wish you luck in going forward, sir.
Thank you, sir. At this point, are there any other questions for our witnesses? I don't have anybody else on the list, so without objection, we'll go back into session. We're back into session. Representative Holsey's on the list.
Yes.
Representative Holsey was on my list. He is recognized at this point. No one else is recognized. There was not a motion recognized. There's no one recognized except Representative Holsey.
Mr. Chairman, thank you. I was going to, before they start throwing rocks at me, I'd like to have a meeting with the Attorney General. And so I was going to make a recommendation or a motion to roll this one more week till we can sit down.
We have a proper motion. Do we have we have a second? We will be voting on the motion to roll this bill 1 week.
We have a roll call vote. Roll call vote.
We are having a roll call vote. You are not recognized to speak until I recognize you, sir. We will have a roll call vote, Mr. Clerk. We're voting, just to make sure everybody knows, we're voting to roll this 1 week. That's the motion that we have at hand.
All right. Representatives Fritz? Yes. Fritz votes aye. Representative Grills? Yes. Grills votes aye. Representative Hardaway? No. Hardaway votes no. Representative Harris? No. Representative Harris votes no. Representative Holsey? Yes. Holsey votes aye. Hurt? Yes. Hurt votes aye. Jones? No. Jones votes no. Marsh? No. Marsh votes no. Martin? No. Martin votes no. Reedy? No. Reedy votes no. Ritchie? Yes. Ritchie votes aye. Shaw? No. Shaw votes no. Todd? Aye. Representative Todd votes aye. Representative Travis? No. Travis votes no. Vital? No. Vital votes no. Representative Wright? Yes. Wright votes aye. And Representative Darby? No. Representative Darby votes no. Mr. Chair, we have 7 ayes, 10 noes.
Motion fails. We're back on the bill. We have a motion to move for previous question and a second. Is there any objection to the question? We have an objection. We'll be voting with a roll call vote on previous question.
Isn't it 3 hands?
One moment, Representative Shaw has a point of order.
Thank you. If we're voting to we should vote yes if we in favor of voting today, right?
Yeah, the motion is previous question.
All
that
right,
we're
so
voting
we
on.
should vote yes. Oh, thank you.
Mr. Clerk. All right. One more time. The vote right now is for previous question, which will stop debate. We'll have no more debate on the bill, and we'll be then moved to vote on the bill.
Representative Fritz? No. Votes no. Representative Grills? No. Representative Grills votes no. Representative Hardaway? Yes. Representative Hardaway votes aye. Representative Harris? Yes. Harris votes aye. Holsey? No. Holsey votes no. Hurt? No. Hurt votes no. Jones?
Yes.
Jones votes aye. Marsh? Yes. Marsh votes aye. Martin? Yes. Martin votes aye. Reedy? Yes. Reedy votes aye. Ritchie? No. Ritchie votes no. Shaw? Yes. Shaw votes aye. Travis? Yes. Travis votes aye. Vital? Yes. Vital votes aye. Wright? No. Wright votes no. Vice Chairman Darby? Yes. Vice Chairman Darby votes aye. Chairman Todd? No. Chairman Todd votes no. Mr. Chair, we have 10 ayes, 7 noes.
Previous question prevails. I reconsider my actions. Previous question fails. It requires a 2/3 majority. I'm corrected. Motion fails. We're back on the bill, and we do have an amendment, drafting code 5784 before the committee. Do I have a motion on the amendment? I have a motion. Do I have a second? We have a second on the amendment. This is drafting code 5784. Rewrites the bill, designates a portion of this particular portion of the Duck River as a Class 3 developed river area. We'll be discussing that at this moment. Representative Sapiki, you are recognized.
Thank you, Mr. Chairman. For clarification, can I ask which member submitted that?
Speaker Pro Tem Marsh.
Can I ask a question to Speaker Pro Tem Marsh, Mr. Chairman?
You may address the committee.
Thank you. Committee and Speaker Pro Tem Marsh, with the votes that are looking like we've just been taking place, do you still want to put this amendment through, or do you want to withdraw it?
Representative Sapiki, the motion is before the committee. It's not, it's been submitted to the committee. The committee has adopted it at this point. We have a motion and a second. We have not adopted it. So it's up for debate at this point.
So, question back to the chairman. As a member who's filed many amendments up here on bills, this amendment is still under the control of the person who presented it. They can withdraw that at any time as long as whoever gives the second says it's okay. So I think out of respect to the people that have come behind me who are looking for a vote today, Mr. Chairman, I think a quick question to the sponsor of the amendment, with what the votes have been taking place here, can we just ask that member if he would withdraw that amendment and we can take the vote for the people, sir?
Well, we have a bill, an amendment before us that has a motion and a second. It's no longer, it's to be voted on, debated and voted on. It is the proper position we're in at this moment.
I would request clarity from the clerk on that. I would respectfully request clarity to the clerk.
Representative Ritchie.
Thank you, Chairman. I know we've got a hard stop at 10:30. I make a motion to adjourn.
Oh, my.
We have a proper motion. Do we have a second?
This is because of the chair, but know that committee. Know that this is the chairman's decision.
You are out of order, sir. Do we have a second on the, we have a second on the motion to adjourn.
Vote no. Say no.
Mr. Clerk, please
no.
take the roll.
It's got to take a roll vote.
Yeah.
A roll call vote.
All right. Representative Fritz? Aye. Fritz votes aye. Grills? Yes. Grills votes aye. Hardaway? No. Hardaway votes no. Harris? No. Harris votes no. Holsey? Yes. Holsey votes aye. Hurt? No. Hurt votes no. Jones?
No.
Jones votes no. Marsh? No. Marsh votes no. Martin? No. Martin votes no. Reedy? No. Reedy votes no. Ritchie? Yes. Ritchie votes aye. Shaw? Shaw votes no. Travis? Travis votes no. Vital? Vital votes no. Wright? Wright votes aye. Vice Chairman Darby? Vice Chairman Darby votes no. Chairman Todd? Chairman Todd votes aye. Mr. Chair, we have 6 ayes, 11 noes.
Motion to adjourn fails. We're back on the amendment before us. Any debate on the amendment? There's a question on the amendment without objection. We will have a roll call vote on the amendment.
Representatives Fritz? Fritz votes aye. Representative Grills? Grills votes aye. Representative Hardaway? Hardaway votes no. Harris? Harris votes no. Holsey? Holsey votes aye. Hurt? Hurt votes aye. Jones?
No.
Jones votes no. Marsh? Marsh votes no. Martin? Martin votes no. Reedy? Reedy votes no. Ritchie? Ritchie votes aye. Shaw? Shaw votes no. Travis? Travis votes no. Vital? Vital votes no. Wright? Wright votes aye. Vice Chairman Darby? Vice Chairman Darby votes no. And Chairman Todd? Chairman Todd votes aye. Mr. Chair, we have 7 ayes, 10 noes.
Motion fails. We're back on the bill. We have question called. Are there objections to calling the question on the bill? Seeing none, we'll be voting on House Bill 447. Mr. Clerk, please call the roll.
All right. Representative Fritz? Fritz votes no. Representative Grills? Grills votes no. Representative Hardaway? Hardaway votes aye. Harris? Harris votes aye. Holsey? Holsey votes no. Hurt? Hurt votes aye. Jones? Representative
Aye.
Jones? Okay. Jones votes aye. Representative Marsh? Marsh votes aye. Martin? Martin votes aye. Reedy? Reedy votes aye. Ritchie? Ritchie votes no. Shaw? Shaw votes aye. Travis? Travis votes aye. Vital? Vital votes aye. Wright? Wright votes no. Vice Chairman Darby? Vice Chairman Darby votes aye. Chairman Todd? Chairman Todd votes no. All right. We have 11 ayes, 6 noes.
The ayes have it. Motion, House Bill 447 passes. We're out of order.
Thank you,
House
Chairman
Bill
of the Committee.
447 passes on to Government Operations Committee.
Thank you.
Motion to adjourn.
Make a motion to adjourn.
We have a motion to adjourn without objection.
Rolling every.
Before we adjourn, House Bill 394 is rolled to next calendar. We are adjourned.